Recently, the Ninth Circuit Court of Appeals dismissed the James Huntsman tithing lawsuit alleging fraud against the Church of Jesus Christ of Latter-day Saints. Find out tonight what's in that opinion, what it means to James Huntsman, what it means to the LDS Church, and what it means to you here tonight on Radio Free Mormon. Testing 1, 2, 3. Testing 1, 2, 3. This is Radio Free Mormon on the air, broadcasting behind enemy lines. Tonight's episode, Mormon tithing lawsuit dismissed. And once again, we are talking specifically about the James Huntsman lawsuit being dismissed by the Ninth Circuit Court of Appeals. What I want to do tonight is go into that opinion, use my legal experience. I've read a lot of opinions, hundreds of opinions of courts in my career as an attorney. And let's take a little bit of time and look at this opinion that was issued recently. Now, here is the first page of the opinion. You can see it's titled James Huntsman against the Corporation of the President of the Church of Jesus Christ of Latter-day Saints. It was filed, or in other words, this opinion was issued and made official and part of the record on January 31st, 2025. A little bit about the background on this case. What happened is that James Huntsman filed a lawsuit against the LDS Church. He filed it in district court in California. District court means it's part of the federal court system. So he is actually making a federal case out of this. Yes, he filed it in federal court alleging violation of California law relating to fraud. All right. So what happened is it goes up in front of one judge. The church made a motion to dismiss, saying we didn't commit fraud. And there's no allegation here that will support a finding by any juror or any jury that the church committed fraud. Trial judge, the district court judge, agrees with the church, dismisses it. James Huntsman then files an appeal to the Ninth Circuit. Now, here's how it goes, okay? You have your trial court level in federal court. That's the district court. The next level is the Court of Appeals, which is called the Circuit Court in federal judiciary language. That's the Circuit Court. And above that is the Supreme Court. So there's three levels. There's the initial level, the trial court level. There's the Circuit Court, which is the Court of Appeals. And then there's the Supreme Court of the United States. So that's the system. So what happened was that James Huntsman files his lawsuit, as he should, in the first level, district court, gets dismissed by the judge. James Huntsman then files an appeal to the Court of Appeals, which is the Circuit Court. It is the Ninth Circuit Court of Appeals because that is the circuit that covers this area of California as well as other states. Now, on appeal, James Huntsman won the appeal because he appeared in front of a panel of three judges at the appellate court level, the circuit court level. He argued his case. Two of those judges agreed with him that his case should not be dismissed and remanded it back to the district court for trial. If you get two judges out of three to agree with you, that means you win. Now, what the church did at that point was they did something a little bit unusual. Instead of appealing that decision to the Supreme Court, which would be the next level, they requested the entire Ninth Circuit Court of Appeals, all the judges on all the different panels within that same circuit, to get all together, en banc is what it's called, get all together and rule on this case. Instead of just having three judges from this entire panel, everybody needs to get on board and everybody needs to render a ruling on this. And that's what they agreed to do. So that's what this case is. This is the entirety of the Ninth Circuit Court of Appeals judges who are not recused or not involved earlier on, rendering their opinion. And they agree with the church, and that's why it got dismissed. Now, there were 11 of these judges in this en banc hearing, and they ended up signing this opinion. So there are three opinions here. There is a majority opinion, there is a concurring opinion, and then there is another concurring opinion. A little bit of a note about what that means. The concurring opinion means that you agree with the majority opinion, you agree with the result they got, but you don't necessarily agree with how they got there. So you write a separate opinion to clarify why it is you think they were wrong about how they got there, but you agree with where they got to anyway. So it's a concurring opinion. The other kind of opinion is a dissenting opinion, which means that you disagree with the result that the majority arrived at. However, in this case, there are no dissenting opinions. Everybody agreed with where the majority got to in dismissing the James Huntsman lawsuit against the LDS Church, although they would have arrived there by different means. And here, once again, on this first page of the opinion, filed January 31st, 2025, and then beneath that, you can see the 11 names of the different judges who heard this case and issued the rulings and the opinions in this case. As I said, there were 11 judges on the panel. Here is the summary. Now, in every Supreme Court case, you're going to have a summary at the beginning, which is really helpful for the layperson to be able to read, and they're going to be a lot more likely to be able to understand the summary than if they start going into the entire opinion without any training in the law. It ends up getting complicated. Believe me, it took me a long time to be able to read these opinions and to be able to understand them with any degree of clarity. Now, I want to get through this explanation of the lawsuit in under an hour, so I'm going to speed through it here. There's no reason that we should spend longer than an hour talking about this one opinion, but it is very interesting, and there is a great deal to talk about. So I'll get started here. The en banc court affirmed the district court's order granting summary judgment to the Church of Jesus Christ of Latter-day Saints, which will be called the Church in the opinion, in an action brought by James Huntsman, a former member of the church, alleging that the church had committed fraud by using tithing funds to finance commercial endeavors, despite stating that it would not do so. So that is the Huntsman position of the lawsuit. Huntsman contended further that the church committed fraud under California law by misrepresenting which funds it used to finance the City Creek Center project, a redevelopment of a commercial shopping mall in downtown Salt Lake City, Utah, and which funds were used to allegedly bail out the Beneficial Life Insurance Company, a church-owned entity, period. Huntsman tithed substantial sums to the church from 1993 to 2015. So here is what the en banc court, that means all of them together, decide. The en banc court held that no reasonable juror could conclude that the church misrepresented the source of funds for the City Creek project. It gets thrown out. What this court of appeals is saying to Huntsman is, you've got no case. There is no juror in their right mind who would ever agree with you that this constituted fraud on the part of the church. Therefore, you're out of here. You don't even get to a jury trial. So this is quite a ruling from the Court of Appeals. The en banc court held that no reasonable juror could conclude that the church misrepresented the source of funds for the City Creek project. That was their holding, all 11 of them. The church had long explained that the sources of the reserve funds included tithing funds, and Huntsman had not presented evidence that the church did anything other than what it said it would do. The en banc court held that Huntsman's claim with respect to the $600 million allegedly transferred to Beneficial Life also failed. Huntsman did not identify any specific statements made by the church about the source of funds for Beneficial Life. Accordingly, the record did not support a claim of fraudulent misrepresentation, which is what is alleged under the fraud statute in California. You have to show that the church, or whoever it is you're suing, committed fraud. And if you can't show that, then you're going to get thrown out of court. If you can't show that any reasonable juror would have found for you, then your case gets thrown out of court and you don't even get to a jury trial. That is what is called a motion for summary judgment. We'll talk about that a little bit more here in a second. Finally, the en banc court held that the church autonomy doctrine, that's the First Amendment, churches get to do what they want to do. Churches are protected by the First Amendment from government influence or interference in what it is that the church is doing. So that's the church autonomy doctrine. And the en banc court also held that the church autonomy doctrine, the First Amendment, had no bearing in this case because nothing in the court's analysis of Huntsman's fraud claims delved into matters of church doctrine or policy. So the implication here, at least as far as the majority opinion goes, is that the First Amendment protection for churches does not apply here. It does not prevent the court from looking at the fraud statute and saying, hey, there was never a fraud, because that's what they're saying. The church never committed fraud. And in fact, nobody in their right mind would ever believe, based upon the evidence presented, that the church committed fraud. Now, in the last two paragraphs here, they're going to go into the other two concurring opinions. I'm not going to go into those right now. Let's go ahead and look at the opinion itself instead of the summary. 5 out of 11 judges concurred that the First Amendment church autonomy doctrine would defeat Huntsman's claims. All right. So the first 6 people, the first 6 judges, it's 6-5, right? 6 is the majority. They write the majority opinion. They hold there was never any fraud by the church, and they don't even reach the First Amendment protection. They say we don't even have to get to the First Amendment because there was no fraud in the first place. The other 5 judges in the panel who wrote the 2 concurring opinions, they agree on the idea that the First Amendment church autonomy doctrine would defeat Huntsman's claims anyway. They end up agreeing with the majority that there's no fraud, but 5 out of the 11 judges say, sorry, the First Amendment protects the LDS Church even if these claims were true and could be proven, right? Even if, sorry, First Amendment protects the church. So let's look at that a little bit too. Summary of opinions. The majority opinion, 6 of 11 judges, resolved the appeal holding no fraudulent representations were ever made by the church, and that the First Amendment does not prohibit them from reaching this decision. The second opinion, which is a concurring opinion, I'll sometimes call it the first concurring opinion, because 4 out of 11 judges signed off on this concurring opinion. The final concurring opinion, the third opinion, only one judge disagreed enough that he or she thought it was important enough to write a separate concurring opinion all on their own. Nobody else joined the third judge. The first concurring opinion, 4 out of 11 judges agree with the majority that Huntsman loses on the fraud claim, but they also hold that the First Amendment bars Huntsman's claim as well. Finally, this third opinion, the second concurring opinion, one judge agrees that Huntsman should lose, but also holds the majority can't even get to the definition of fraud because they have no authority to decide the case on the merits because the First Amendment gives the court no jurisdiction. So this last person, this rogue judge, says the majority has to do a First Amendment analysis first before they even get to the fraud issue. And if they do the First Amendment analysis, they'll find that there is a protection there, and this lawsuit can't even go forward. And in fact, the judges can't even reach the fraud issue because it's protected by the First Amendment. So we have these 3 decisions, these 3 opinions from different judges in the panel, but all of them holding that Huntsman loses. That's why it's a majority opinion, a concurring opinion, and a concurring opinion. There's no dissenting opinion among them. By comparison, none of the 4 judges who have previously ruled on this case, remember there's a district court judge, the first judge at the trial court level, then there were the 3 judges on the Court of Appeals who heard that first appeal, which was then vacated in favor of doing the en banc hearing. Out of those 4, all of them agreed that the First Amendment did not protect the church here, that this was exclusively a secular issue to which First Amendment religious protections did not apply. So you've got 4 judges already going into this who have ruled no First Amendment protection. But when they get up to the panel, the en banc panel at the Court of Appeals, the Ninth Circuit, there are 5 of those 11 judges who hold the First Amendment protects the church, and you can't get past it. So that's very interesting, and it shows that among judges, all of whom I'm sure have distinguished careers and a lot of experience, there are differences of opinion, even amongst the most educated and experienced judges in the Court of Appeals, in the federal system. 5 of them say First Amendment applies and protects the church and bars the lawsuit, and then there's a bunch of others who say, no, it doesn't. So this is the problem, right? This is one of the problems, because it depends on what panel you pick. Here, the first panel that was picked for Huntsman favored him 2-1. Then it went to the entire panel of 11, and they all tube him. 6 of the 11 saying that there was no fraud and we don't even have to get to the First Amendment, and the other 5 saying First Amendment bars the lawsuit. So there's a lot of luck of the draw when it comes here. Talk about leadership roulette. This is judicial roulette. The first claim has to do with church funding of the City Creek Mall. And the allegation there by Huntsman was that this was obtained through fraudulent means and misrepresentations by the church. The other issue had to do with the beneficial life insurance and the propping that up by an infusion of $600 million from the Ensign Peak account. The beneficial life insurance issue is the least strong argument that Huntsman had, because there really are no statements that he has from anybody in the church about how those funds would be used to show, or at least allege, that there was fraud involved. So church funding of City Creek Mall, this is his best issue. And here's what the opinion says. To explain the funding of the City Creek project, the church submitted 2 declarations. That means something in writing, signed under penalty of perjury by a person who would know, a witness. The first declaration by a director in the church's finance and records department named Paul Writing stated that all the funds allocated to the City Creek project came from earnings on the church's reserve funds invested by Ensign Peak, meaning that no principal reserve funds, i.e. funds taken directly from church members' tithing contributions, were used. Okay, this is important. And the majority opinion goes along with this particular argument that the church has been putting forward from the beginning, which is that we have tithing, which is collected from the membership, donated by the membership, put into the coffers of the church, and then it is invested in stocks, both U.S. and foreign, real estate, all sorts of investments. That this tithing that isn't used for the operating expenses of the churches gets put into this investment account. So the question is, how much of this is tithing, right? The principle of the tithing versus what is the interest that was accrued or gained on this tithing after it was invested. And the issue then becomes whether the church invested any of the principle of the tithing that it took from the members, or whether it invested only the interest that was gained from that tithing through investments. All right. That'll be an important issue. And that's what they're talking about here. Writing or Writing testified through signing the declaration that Ensign Peak's assets included both reserve funds and earnings on invested reserve funds. So there are reserve funds there, but there's also the earnings that have been accrued through the investment of those funds, just like I talked about. In 2003 alone, Ensign Peak accumulated approximately $3.9 billion. It will be an important number. Just the 3.9 is all you have to remember. It's billion, though, of earnings on invested reserve funds. So they got the principal there from the tithing. And in 2003, based upon this declaration, which was unchallenged, it stated that the church earned in investment income $3.9 billion in 2000, and which is important because the lawsuit is talking about the City Creek Mall, which was funded by the Ensign Peak account around this time. The opinion goes on. On January 1st, 2004, several months after the church announced the City Creek project, Ensign Peak allocated $1.2 billion into an internal account earmarked for the project. So they take $1.2 billion, they put it into another account. It's earmarked for the City Creek Mall. Those earmarked funds were themselves invested and reached a total value of nearly $1.7 billion before any appropriations were made for the City Creek project. Then from 2007 to 2012, Ensign Peak periodically appropriated funds from this account to a separate entity that managed and owned the church's investment in City Creek. In total, approximately $1.4 billion was appropriated for the City Creek project. Writing supported the foregoing testimony with Ensign Peak financial documents. So it's not just his word for it, he's also supporting with documents that the court is reviewing and referencing here in this part of their opinion. So to break this down even further, 2003, there's $3.9 billion of interest. From that $3.9 billion, the church argued and the court agreed, $1.2 billion was taken, which is less than $3.9 billion, put in the fund earmarked for the City Creek Mall. That was invested. It grows to $1.7 billion. And then over time, less than the $1.7 billion is spent on the City Creek Mall. $1.4 billion is how much was spent on the City Creek, which is obviously less than $1.7 billion. So what they're saying is it was all interest. It wasn't principal. If they had spent more on the City Creek Mall or anything else, but let's say the City Creek Mall here, if they had spent more on that than the interest that came in, then they would have had to have spent some of the principal, obviously. But as long as it was less than the interest coming in, who is to say whether it was principal or whether it was interest? Now we go to the procedural history, which thankfully I've already covered in the opening of this episode, talking about where it was filed in district court, the first round of appeals, then going to the en banc hearing in front of the Ninth Circuit. We'll skip this part and go to summary judgment. What is summary judgment? This is from the opinion where it defines summary judgment. We review the district court's grant of summary judgment de novo. Summary judgment is proper when, here's the definition, viewing the evidence in the light most favorable to the non-moving party, here Huntsman. Church is moving for summary judgment, asking the court to dismiss Huntsman's case. So all the evidence is viewed in the light most favorable to the non-moving party, here Huntsman, and only is a motion for summary judgment to be granted if there is no genuine issue of material fact. So there's basically 3 steps to summary judgment. First off, obviously, one party brings it against the other party. It would typically be the defendant bringing it against the plaintiff, right? And that's what it is here. So the first thing is this, is all the facts have to be agreed. They were here. In many cases, facts are not agreed. If facts are not agreed, it has to go to a jury because a jury is the finder of fact. A judge is not the finder of fact unless the parties agree to it and they have a bench trial where only a judge sits as the jury. Typically, though, a jury is the finder of fact, the judge is the finder of law, and those 2 roles are not to be mixed at all. It is very important in the law to preserve the right to a jury trial and to preserve to different people the ability to have their peers make decisions on fact. What that means is simply this. If there are contradicting facts that are presented, one witness says one thing, another witness says another, they can't both be true. It is up to a jury to decide what really happened. They can look at credibility. They can say, who do we believe, who had a better opportunity to observe? What bias might this witness have? That's exclusively for the jury. That's why they're the finder of fact. They determine what happened. Judges don't get to do that. Judges get to determine the law, which means that if there is a legal motion or a motion to suppress or many other kinds of motions that have to do with the law, the judge makes those rulings, but the judge can't make a ruling as to what happened in the case. What are the facts of the case? So the first thing is, if you've got a motion for summary judgment, all the facts have to be agreed. If they're not agreed, there's no summary judgment. It has to go to trial because you have to have a jury make the decision. All the facts have to be agreed. Number 2, all the inferences from those facts are drawn in the light most favorable to the non-moving party, here, James Huntsman. And finally, only if the judge or judges here say that nobody in their right mind, or as the legal language is, no reasonable juror could find for Huntsman, right? Then it's kicked out. So you say, we're not going to have a jury trial. This is what the judges say. We're not going to have a jury trial if no reasonable juror could find for you anyway. So we're just going to dismiss it. That's what a motion for summary judgment is. All right. And this is what the entirety of the 11-judge en banc panel of the Ninth Circuit Court of Appeals held was appropriate that this be dismissed. Elements of fraud in California. Remember, this is proceeding under California law, and therefore the definition of fraud in California is what applies in this case, even though it's a federal case. Huntsman claims that the church committed fraud under California law. The elements of fraud under California law are, now they get all the different elements. I'm not going to go through them all. We don't have to go past the first one. A, misrepresentation, false representation, concealment, or disclosure. The reason we don't have to go beyond that is because this is the one that the majority opinion finds the church didn't do. Not only did the church not do it, nobody in their right mind could believe the church did it under the facts presented here in this case by both the church and the facts presented by Huntsman. And now the opinion goes into why it is that they believe and hold that this is the case. No reasonable juror, they write, could conclude that the church misrepresented the source of funds for the City Creek project. Although the church stated that no tithing funds would be used to fund City Creek, it also clarified that earnings on invested reserve funds would be used. That's the interest, as opposed to the principal being distinguished. The opinion continues. President Hinckley qualified the assertion that tithing funds would not be used, because he said that, right? And other people said that later on. And Huntsman is relying on their statements, but they're going back to this earlier statement by President Hinckley and the clarification that he put on that statement. President Hinckley qualified the assertion that tithing funds would not be used by noting that earnings on invested reserve funds would be used. In his 2003 announcement of the first City Creek project, Hinckley stated, "Tithing funds have not and will not be used to acquire this property." Now that sounds pretty black and white, doesn't it? Nor will they be used in developing it for commercial purposes. But he goes on, "Funds for this have come and will come from those commercial entities owned by the church. These resources, together with the earnings of invested reserve funds," that's it right there. That's why it's in italics in the opinion. "These resources, together with the earnings of invested reserve funds, will accommodate this program." So not only funds from commercial entities owned by the church will pay for City Creek Mall, but also the interest on the invested reserve funds. Now, we didn't know about what they had going with the invested reserve funds. President Hinckley certainly knew what they were doing, right? With the EPA. The federal government didn't even know about the EPA at that point, and they wouldn't for a long time to come, but he knew. So even though there are several statements by different church authorities subsequent to this that say black and white, no tithing funds will be used, and even though President Hinckley in this statement says at the very beginning of it, black and white, tithing funds have not and will not be used to acquire this property, he goes on to clarify what he means by tithing funds by saying that we will use the earnings of invested reserve funds. Okay. The investment comes from the tithing. It's invested. The earnings we will use. And according to the calculations, that is indeed what happened. So much so that the Ninth Circuit Court of Appeal says no juror in their right mind could find that the church committed fraud by misrepresentation. Going on, that statement thus drew a distinction. That statement by President Hinckley thus drew a distinction between principal tithing funds coming directly from church members and earnings on the funds that the church sets aside from its annual income, which includes tithing funds. The four subsequent statements that Huntsman points to, the ones that are black and white about no tithing being used, which state without qualification that tithing funds were not used for City Creek, can only be understood within the context of Hinckley's earlier statement distinguishing between tithing funds and earnings on reserves, and they therefore do not support Huntsman's fraud claim. So what this opinion is basically saying is that even though church authorities and in its official magazines and publications 4 times after this said unequivocally that tithing will not be used to fund City Creek Mall, all of that goes back to 2003 to this statement by President Hinckley, and they say this statement by President Hinckley qualifies all of these unqualified statements that were made later on, so much so that no reasonable juror could find that the LDS Church committed fraud. It goes on. Ensign Peak's financial records are consistent with the church's statements that it funded City Creek with earnings on invested reserve funds. The undisputed evidence in the record indicates that Ensign Peak's investments earned approximately $3.9 billion in 2003 alone. We talked about this earlier in the opinion, which was more than enough to cover Ensign Peak's allocation on January 1st, 2004 of $1.2 billion to the earmarked account for City Creek. The undisputed evidence further indicates that the earmarked funds were invested and increased in value to a total of nearly $1.7 billion before any funds were appropriated for City Creek. The approximately $1.4 billion in total funds appropriated for City Creek thus in no way belies the church's statement that City Creek would be funded by earnings on invested reserve funds, because each relevant Ensign Peak account held enough earnings on invested funds to cover the funds appropriated for City Creek. Any commingling of principal tithing funds and earnings on invested tithing funds cannot support Huntsman's fraud claims. Now, whether you agree with that, that is the heart of the opinion, I think, in this regard, the heart of the majority opinion, at least. This is why they find that the church was not being fraudulent in representing the funds that would be used to pay for the City Creek Mall, because of this analysis right here in this part of the opinion. And if you remember nothing else from this opinion, this would probably be the thing to remember. Okay, so I want to give you a real world example of this to help explain why it is that they came to this conclusion in the Ninth Circuit. Let's deal with a tax refund, shall we? I'm recording this on February 7th, 2025, and it's getting to be tax season. So these are timely tax refunds and always welcome. Now, imagine if you get a tax refund of $1,000 and put it into your bank account with your other money. And in your bank account, you already have $5,000, right? So 1,000 plus 5,000, 6,000, easy. Then you spend $500 out of that account for whatever. Who is to say that the $500 you spent came from the tax refund or what you already had in the account? Or perhaps put a different way, that $500 that was spent out of the account, I'll put the question to you. Was that $500 from the tax refund or was that $500 from the principal that was already in the account? How would you answer the question? I think the answer is you can't tell. How would you know? Money is fungible in nature, which means it's completely able to be switched out. This will be the word of the day, fungible, being something such as money of such a nature that one part or quantity may be replaced by another equal part or quantity in paying a debt or settling an account. It's all the same. Money is fungible, right? It's not like a certain number of yellow balloons and a certain number of blue balloons. It's just all money. So there's really no telling which is the interest and which is the principal in a situation such as this. Let me give you another example. Tax refund example number 2. If you get a tax refund of $1,000 and put it into your bank account with your other money, but in your account, once again, you have $5,000. We'll use the same facts. Here's where we change the facts. Then instead of spending $500, you spend $1,500. Who is to say that the $1,500 you spent came from the tax refund or what you already had in the account? Well, we know that you had to go, in this example, into the principal by at least $500 because there was only $1,000 tax return. You spent $1,500. At least $500 of that is from the principal that was already in the account. It can't be calculated any other way. That's not what happened here, though, right? They had enough that came into the account in this way, like the tax refund. Let's go back to that first example. This is the example that is most like what it is the church did and why it is the Court of Appeals found for them. Because the amount that they spent was less than the amount that was earned on the principal. Therefore, we can't say whether it was principal. It could have been all interest. And in fact, that's what the church is claiming it was, all interest. So once again, there's tax refund. Example number 2. I've got one more example. If you get a tax refund of $1,000 and put it into your bank account with your other money, but in your bank account now, in this example, you only have $500, okay? Then you spend $1,500. Who is to say that the $1,500 you spent came from the tax refund or what you already had in the account? We know in this example, right? Because you only had $500 in your account, not the $5,000. If you only have $500 in your account, put $1,000 in from the tax refund, and then you spend $1,500 or everything, we know that you had to spend the $500 that you had in principal. These examples, these tax refund examples, number 2 and number 3, are hopefully to give you an alternative example of what it would have to look like in order for the Court of Appeals to rule for Huntsman in this case. But because it looks not like number 3, number 2, but number 1, there's no way of saying. So therefore, the church gets to call it whatever the church wants to because it is fungible. And the church calls it interest, and it's not more than the interest that was accrued. Therefore, it's interest, as far as the court's concerned. David Nielsen's declaration does not contradict the church's claim. This was another important part of the opinion. David Nielsen signed a declaration, the whistleblower who used to work at the Ensign Peak account offices. And here's what they say about this. Nielsen's declaration does not contradict the conclusion that Ensign Peak held sufficient earnings on invested reserve funds to fund the project without using principal tithing funds. I hope that that language is starting to make more sense to you if it didn't before, after these examples and after this discussion that we're having. Nielsen testified in his declaration that Ensign Peak's senior leadership and other employees referred to all Ensign Peak funds as tithing money, regardless of whether they were referring to principal or earnings on that principal, and that the approximately $1.4 billion that Ensign Peak appropriated for City Creek came from tithing funds. Okay. What they end up saying is it doesn't make any difference what they call it. Who cares what they called it? That's not really relevant. What we're looking at is the actual math and the principal and the interest. The presentation slide that Nielsen submitted with his declaration indicated that $1.4 billion, that's what I understand 1,400 millions to be, is 1,400 million, over 5 years was withdrawn from Ensign Peak's investment reserves for City Creek, even accepting the facts asserted in Nielsen's declaration is true. They do not show that principal tithing funds were used for the City Creek project. See, that's where they're focused. Neither Nielsen's statement nor the Ensign Peak presentation slide distinguished between principal and earnings, so neither statement contradicts President Hinckley's public statement that only earnings would be used. They also do not conflict with Ensign Peak's financial records, which show that Ensign Peak held sufficient earnings on reserve funds to finance City Creek. Once again, they've got more than enough earnings over and above the tithing principal to fund City Creek Mall. Therefore, you can't show that tithing was used. Not with this 2003 statement by Gordon B. Hinckley that is clarifying that tithing funds are not used, but earnings that were obtained as interest based upon the investment of those reserve funds. Were the representations ambiguous? So there is a secondary fallback position that obviously Huntsman availed himself of, tried to avail himself of. It was to no avail. But to say even if they weren't intentionally trying to defraud, they were still being ambiguous in what they said to the point where a reasonable person would get the wrong impression, okay? And that they did this on purpose or with reckless disregard for the truth of the matter. The opinion says, finally, the term earnings of invested reserve funds was not so ambiguous that the church could have expected or intended its relevant audience here, Huntsman, to misunderstand what it meant. All right? So the church also holds it wasn't ambiguous. It was clear. He understood, could have understood, should have understood what it was that the church was talking about and what President Hinckley specifically was talking about when he talked about the source of funds for the funding of City Creek Mall. Then we get to the second issue, $600 billion for beneficial life. That gets made short shrift of because there are no statements produced by Huntsman in support of his claim that the church was misrepresenting to anybody the source of funds that would be used for beneficial life. Here's how the opinion puts it. Huntsman's claim with respect to the $600 million allegedly transferred to beneficial life also fails. Huntsman does not identify any specific statements made by the church about the source of funds for beneficial life. Instead, he points only to Sunday school manuals and conference addresses that generally spoke about how tithing funds were used, as well as the 2012 statement in the Salt Lake Tribune that, quote, McMullen said not one penny of tithing goes to the church's for-profit endeavors. Because the record contains no representations by the church about beneficial life in particular, it does not support a claim of fraudulent misrepresentation. And honestly, I don't know exactly that I agree with that, because if an official for the church says in the Salt Lake Tribune that not one penny of tithing goes to the church's for-profit endeavors, and if beneficial life is a church for-profit endeavor, which I believe it is, and if $600 million of tithing, as the allegation is, was used to help bail them out, then it does kind of sound to me like it could support a claim of fraudulent misrepresentation. But as I say, the Ninth Circuit Court of Appeals disagrees, and this is the opinion saying so. So here's the church autonomy doctrine. We already talked about that a bit before. Here is a more formal definition. Finally, the church autonomy doctrine has no bearing here. This is the majority opinion. That doctrine protects First Amendment values by prohibiting courts from resolving controversies over religious doctrine and practice. Because nothing in our analysis of Huntsman's fraud claims delves into matters of church doctrine or policy, our decision in this case does not run afoul of the church autonomy doctrine. So they're basically saying First Amendment doesn't apply. We are tacitly holding First Amendment protections don't apply here, but we can resolve this issue on the fraud claim alone and just say nobody would ever find fraud under these facts against the church. For the foregoing reasons, we affirm the district court's order granting summary judgment to the church. Then there's the first concurring opinion, which I already talked about, signed by 4 judges. And I want to read to you some quotes from these 2 concurring opinions, because both of these concurring opinions do a First Amendment analysis. And I want you to hear some of the language in these First Amendment analysis sections of these 2 concurring opinions. The reason I want you to hear them is because these are powerful arguments that come from the root of freedom of religion in the United States of America and has been part of this system of government ever since its inception and the creation of the Constitution. Here is this first quote from the first concurring opinion. A prominent disaffected member of the Church of Jesus Christ of Latter-day Saints is suing the church seeking a refund of religiously commanded tithes because the church's leader made purported fraudulent misrepresentations during a religious address to the church. This lawsuit is extraordinary and patently inappropriate, a not so thinly concealed effort to challenge the church's belief system under the guise of litigation. The majority is correct that there was no fraudulent misrepresentation, even on the terms of plaintiff's own allegations. But it would have done well for the en banc court to recognize the obvious. There is no way in which the plaintiff here could prevail without running headlong into basic First Amendment prohibitions on courts resolving ecclesiastical disputes. Why do these 4 judges feel so strongly that this is the case? They go on. Constitutional protections for religious freedom provide the core principles that drive the inescapable outcome in this case. The First Amendment protects the right of religious institutions to decide for themselves, free from state interference, matters of church government, as well as those of faith and doctrine. And there they're citing to a Supreme Court opinion stating exactly that. Not just faith and doctrine, but also matters of church government. Courts, therefore, cannot resolve disagreements over church teachings and governance, which would pose grave threats to the autonomy of religious organizations. Yet, governmental intrusion on religion is precisely what plaintiff's suit would require if it were to go any further. Powerful language. Although plaintiff's claims can be rejected even as he styles them, in other words, even as he alleges them, they can be rejected because there was no fraud, which is the approach the majority takes. We should not indulge in the illusion that this is merely a secular lawsuit about civil fraud. Under the First Amendment, the plaintiff's challenge to the church's understanding of tithing is not susceptible to resolution in a court of law. Let me repeat that. Under the First Amendment, the plaintiff's, James Huntsman's challenge to the church's understanding of tithing is not susceptible to resolution in a court of law, lest the judiciary wrest control from religious authorities over matters of theological concern. So the way they're going to frame this is the church is defining tithing in one way. Huntsman, a member or former member, is saying, no, it should be defined another way. And they're saying, well, in such a situation, who gets to define what tithing is for a religion? Not a member, certainly not an ex-member. The head of the religion gets to define it. The religion itself gets to define what tithing means. The opinion goes on. It would have been straightforward and preferable for the court to recognize that plaintiff's unprecedented theory encounters overwhelming First Amendment impediments. While every judge on this panel agrees that the plaintiff's claims fail, I write separately to explain why a suit like this could never succeed under the First Amendment's church autonomy doctrine. The next part of this concurring opinion talks about how the First Amendment protects the church's ability to define tithing how it chooses. It's a very interesting take on the whole issue. The opinion states, in this case, resolving Huntsman's fraud claim in his favor would violate core First Amendment principles. It would do so in 2 main ways. We'll just deal with the first one here. First, for Huntsman to prevail, a court or jury would need to agree with his view of what tithing funds in the church includes. So they're saying, does he get to decide this? Because a jury would have to find that he has the power to decide what tithing funds includes. Does it include just the principal, Or does it include the principal plus the interest? Is all of that tithing funds, right? Who gets to decide? But that would intrude on the church's authority to define that divine concept for itself. In the church, the duty to tithe is a religious commandment from God, and they cite the Doctrine and Covenants to show that that's the case. It is religious in nature. Its definition is religious in nature. What that duty embodies and what the concept of tithing means, including whether tithing funds includes earnings on tithe funds, right? Those are questions of a religious dimension. These matters are for the church to decide on its own within the decision-making hierarchy it establishes. It is not within the judicial function and judicial competence to determine whether Huntsman or the church has the proper interpretation of church practice and belief. According to the church, tithing funds does not include the earnings on such funds. This is not mere lawyer speak, because as I was going through those examples about the tax refunds, and I was talking about who gets to decide what is interest and what is not when it's being expended out of a fund, okay? It's not mere lawyer speak, according to this first concurring opinion. This interpretation, the church says, came directly from the authority of President Hinckley, at the time, God's prophet on the earth, whose religious pronouncements are authoritative. And it cites the D&C for the proposition. As President Hinckley described it at an earlier general conference, tithing is the Lord's law of finance. That's why they're quoting it. It's the Lord's law. It's religious. Vindicating Huntsman's position or agreeing with him and not tossing his suit would effectively take away from the church the authority to articulate through its divinely inspired spiritual leader the contours of holy funds, a matter of core religious significance. The district court below thus had it right, determining whether the term tithing funds encompasses earnings on invested tithing funds would require an analysis of church doctrines and teachings. That is a religious dispute, the resolution of which is for ecclesiastical and not civil tribunals. So here they're agreeing with the underlying district court judge who dismissed the case in the first place. Similarly, we can argue all day long about what the definition of tithing was originally in LDS Church history on surplus, right? We can argue about how much that definition has changed over the years, what it should mean today. We can argue about how Joseph F. Smith said the day would come when members wouldn't need to pay tithing to finance the church and its mission. We can argue all of that stuff. But the bottom line is that the head of the church, who is placed there by the church to render decisions about church matters, gets the final word in defining what tithing is for the church today. And that's the bottom line. None of those arguments that I was talking about, none of that goes to repudiate the fact that the LDS Church, through its modern ecclesiastical leaders, has the right to ignore and even contradict all of that and define tithing the way they wish. Because tithing is religious in nature. The definition of tithing by LDS Church leaders is also religious in nature. This is what the opinion is saying. It is therefore protected by the First Amendment. Now, this next bit is in the first concurrence as well. It's pretty powerful. I want to share it with you. In this case in particular, it is startling to think that courts and juries would be examining a religious sermon, the one by President Hinckley, for accuracy. Think about that. It is startling to think, that courts and juries would be examining President Hinckley's sermon, a religious sermon, for accuracy. See, that's getting into the heart of what the First Amendment is designed to protect against. Religions have the right to run themselves the way they want. So how strange would it be to have government in the form of the judiciary come in to analyze a church leader statement giving in a church setting, general conference, for accuracy? Much less concluding that the leader of a worldwide religion intended to defraud his congregants on religious matters that the church's canonical texts commit to his rightful authority. How can he defraud his own members when the church itself gives him the authority to define things the way he wants? And apparently he did so in that 2003 statement. Nothing says entanglement with religion, which is what the First Amendment is there to avoid. Nothing says entanglement with religion more than Huntsman's apparent position that the head of a religious faith should have spoken with greater precision about inherently religious topics, lest the church be found liable for fraud. Now, the reason I'm reading from this second opinion, the first concurring opinion, is to remind myself, and hopefully to remind all of us, of the strength of the opinion on the other side of the argument. This is why the First Amendment is there in the first place. This is why we have freedom of religion. Freedom of religion is not an unalloyed good. In other words, there's a downside to it, as there are with most things. Most good things have a downside to it. The downside of freedom of religion is that religions can get away with stuff that we might not like, that we might not think is appropriate, that we think government should get involved in. And if it weren't a religion, the government would get involved in it. Does this mean that some people can do things under a religious flag that would be objectionable and against the law otherwise? Absolutely, it does. That is the price for freedom of religion. Because as soon as we get the government getting involved in determining religious questions, that is exactly what the First Amendment was designed to avoid, and is one of the reasons that the United States was created as a country in the first place, was to provide and protect its citizens in their ability to choose and practice what religion they want. As part of that, that means that churches have to have the ability to do what they want, free from government intrusion. And although we may disagree with that and we may see wrong that's occurring, we may have been personally impacted by that wrong and want redress, that's the price for living in a country that allows freedom of religion. You don't get to tell me what to believe. I don't get to tell you what to believe. And God help me, I don't get to go to the government to force you to believe what I believe and do what I think you should do. See? So there's an upside to the issue as well as a downside to the issue. But historically, we have decided as a country under the First Amendment that the upside is much more valuable than the downside. So we want to preserve freedom of religion in this country. Judges are not going to get involved. They're not going to get within 100 miles of getting involved in a religious dispute. And you can see that reflected here. And perhaps we can understand why that is. By the way, I'm going to pause right now for a word from our sponsor.
Hello, friends of Mormon Discussion Incorporated. I'm Bill Reel, founder and CEO, reaching out to our incredible community. Our mission is to support those examining the truth claims of Mormonism and those redefining their relationship with it. Our acclaimed lineup of podcasts, including Mormonism Live, Radio Free Mormon, Mormon Discussion, and others, offers a space for truth and healing. But we need your help. Your donations power our work, expanding our outreach, improving our content, and creating new initiatives. Visit MormonDiscussions.org, click the donate button, and make a difference today. Donate to your favorite show, like this one, as your support empowers us to empower others. Thank you for being a part of the change. Together, we're making real impact.
Thank you, Bill. We're in the middle of that first concurring opinion. Let's go back to it again here briefly. In the conclusion of the first concurring opinion, we find the following. The plaintiff in this case, James Huntsman, is free to criticize his former church and advocate for church reforms, but he cannot ask the judiciary, the government, to intrude on the church's own authority over core matters of faith and doctrine. That is the lesson of this lawsuit. We as courts are not here to MC religious disputes, much less decide them. The First Amendment restricts our role as it protects religious organizations from lawsuits such as this. Period. End of the first concurring opinion. Let's go to the second concurring opinion, signed by one judge. I'm just going to read a little bit from this as well, because I think that he makes some points very well. Here's what this one circuit judge says. Bumate, my colleagues believe we have a choice on how to resolve this case. According to the majority and main concurrence, we can either decide the case on the merits, we can take the Church of Jesus Christ of Latter-day Saints president's word on the meaning of tithing and conclude that the church did not misrepresent its actions. In other words, we can decide it based upon fraud alone and not touch the First Amendment. That's what the majority did. And it's also what the main concurring opinion did. The reason that this judge writes a separate concurring opinion is because he thinks you have to go through the First Amendment to get to any issues of fraud and the church wins and Huntsman loses because of the First Amendment. Or he says we can decide this case based on the church autonomy doctrine, First Amendment, which precludes courts from reaching religious questions and deny the fraud claims. According to this one judge, the Constitution gives us no such choice. In deciding religious matters, the Constitution strictly limits our authority. Simply put, the church autonomy doctrine bars federal courts from resolving matters of faith doctrine and church governance. So we can't just sidestep the doctrine and jump straight to the merits, nor can the doctrine be assumed away, considered an afterthought, or serve as a convenient alternative ruling. And that's how he's characterizing the majority opinion and the main concurrence. Rather, he says, it is a threshold structural bar that must be reckoned with. Otherwise, we violate the restraints the Constitution places on our power. I'm going to respectfully disagree with this judge because, as a general rule, if you've got two things, just like this case, two things that are presented to a court, and one is a secular issue, like is there fraud here? And another one is a constitutional issue. Usually, a judge is going to address the non-constitutional issue first. If you can reach a ruling on a case without invoking the Constitution or a constitutional analysis, that's usually preferred, okay? So actually, that's what the majority did. This lone wolf, this 1 out of 11 individual named Judge Bumate, is disagreeing and saying you have to go through the First Amendment to get there. And if you go through the First Amendment, you'll never get there because the First Amendment decides this case against Huntsman and for the church anyway. Now, the Ninth Circuit Court of Appeals, widely considered the most liberal circuit, 6 out of 11 judges implicitly hold the First Amendment does not apply. 5 out of 11 judges explicit that the First Amendment does apply and that the First Amendment forbids Huntsman's claims against the LDS Church. So maybe the Ninth Circuit is not quite as liberal as it used to be. Now, one thing we can learn from this case, and something that most lawyers know, is that you have to find the right argument to present in a case. It's possible that there are different ways of framing things, and some ways of framing a case or an argument are more effective than others. It's similar to objections in court in a trial. You have to find the right objection. If you're going to object to something that is being stated, witness testimony, an exhibit coming in, you have to give not only the objection, but you have to give the foundation for your objection. You have to know why it is that you're objecting, and you have to tell the judge why it is that you're objecting. And if the court agrees with your foundation, the court will sustain your objection. If the court does not agree with your foundation, the court will overrule your objection. Here's a story, real quick story. I was in a trial. It was a criminal trial. It was in felony court. It was a number of years ago. And there was a witness who was on the stand called by the prosecutor to testify. The prosecutor asked this witness a certain question. I objected. And I stood up and I objected to the judge. It was Judge Cook. And I said, "Objection, Your Honor, hearsay." And the judge said, "I will deny the objection on that basis." Now, a lot of times when judges say things like that, they're actually sort of communicating to the attorney. At least I took it that way. And what I took from that statement was that the judge is saying, yeah, you got a good objection here, but you said the wrong basis for it, dummy. So here's how it went, right? I stood up, I objected based on hearsay. Judge Cook says, "I'm going to deny the objection on that basis." And I'd already sat down. So then I stood up again. I said, "Your Honor, I object based on relevance." And then Judge Cook said, "On that basis, I will sustain the objection." So you have to know what the foundation is, how to present the argument. So I'm just going to say once more what I think a successful argument against the church looks like vis-a-vis this whole tithing problem that they've got going on. And this argument is so simple and so plain and so easy to understand. I can list it in 3 steps on one slide. Number 1, the church took extreme measures to conceal the amount of money it had invested in the U.S. stock market from 1997 to around 2019. That's in the SEC order, the Securities and Exchange Commission order against the LDS Church, finding that the LDS Church committed wrongdoing and that they had gone to great lengths, creating 13 dummy corporations to hide their assets. So people, including members of the church, including the government, including the SEC, wouldn't know how much money the church had. It's not just easy to prove, it's great to prove. And because it's an element of your complaint, you get to prove it. You have to prove it, but you get to prove it. In other words, you get to prove all the stuff that the church did to hide its money, all the stuff that the SEC order encompasses and details, all the 13 dummy shell companies, everything. For how long? For basically over 20 years. The LDS Church was doing that, and you get to prove that in your case. That's number one. And because it has already been decided in a separate judicial proceeding, it's quasi-judicial, but the church agreed to it by signing off on the SEC order, the church now really can't do a lot to say, no, we didn't mean that, because it's already been decided. Number two, the church took these extreme measures because they didn't want members to know how much money they had for fear members would not pay tithing. And Roger Clark, the head of Ensign Peak during this entire time period, stated that on the record to the Wall Street Journal. So we've got it, right? We know that the church engaged in a lot of activity to hide how much money it had, which was substantial, from its membership. We have the head of Ensign Peak stating that the reason the church did that is so that members would continue to pay tithing, because if they knew how much money the church had just in the U.S. stock market, they might not be paying their tithing. Boom. So now, putting those two things together, that creates the ability, I believe, of a lawsuit and a class action lawsuit of a group of people who can truthfully state the following. If a tithe payer, so a member of the church and a tithe payer during that time period, 1997 to 2019, would not have paid tithing if they had known how much money the church had in the U.S. stock market, remember what they were concealing, that is a theory I think can win in court. That is a theory I think will not be dismissed on summary judgment. That is a theory I think you can go all the way to the bank on. Imagine being on a jury in a case like that and hearing all the evidence about all these dummy companies that the church made in order to conceal from the federal government and its own members how much money it had. Oh yeah, all those details. Think about what a jury would think about that and think, wow, this doesn't seem right. So the way that James Huntsman framed the lawsuit got dismissed at the Court of Appeals. A lawsuit along the same idea, still having to do with tithing, but incorporating this SEC order as I have detailed it here, I think that has legs. I think that can go places, and I hope that it will at some point in the future. So what's next for James Huntsman? Well, James Huntsman can either take this dismissal and go home, or he can appeal this dismissal by the Ninth Circuit Court of Appeals to the Supreme Court. There's something I got to tell you, though. He doesn't have a right to appeal it to the Supreme Court. From the district court, the original level, he has the right to appeal to the Court of Appeals, which is the circuit court. From the circuit court, he doesn't have the right to appeal it to the Supreme Court. Instead, he can ask the Supreme Court to hear the case, and the Supreme Court can accept that request or deny that request. He doesn't have the right to have the Supreme Court hear his case. That's called a writ of certiorari. That's what the request is to the U.S. Supreme Court, to ask them to hear the case. If they don't hear the case, if they say, no, we're not going to hear the case, then the decision by the Court of Appeals en banc stands as the final ruling in the case. On the other hand, if they say, yes, we do want to accept this case and we are going to hear about it, then it's going to take months and months and even years longer to get a ruling from the Supreme Court. And who knows what they may say. The only thing we know is that it will cost James Huntsman a lot more money to appeal it to the Supreme Court. But money doesn't seem to be much of an object for James Huntsman. So I suspect that he will file a writ of certiorari to the U.S. Supreme Court, and we'll find out if he does that. I believe he has 30 days from the date of the ruling, January 31st, in which to file his petition for a writ of certiorari to the Supreme Court. And if he does that, I'll be here to report on it. I'm kind of hoping he does, don't you? Well, that's about all for tonight. Thank you for joining me. Please hit the like button. Please hit the subscribe button. And like Bill Reel says, please go to radiofreemormon.org if you have not already and make a donation there today. A continuing donation, a monthly donation would be optimal, $5 a month. All we ask, your donations do keep Radio Free Mormon broadcasting behind enemy lines. Well, that's about all for tonight. Until next time, this is Radio Free Mormon signing off the air.